Today's big issue was pensions protection for firefighters who were hurt on duty, after a decision last year which took away the pensions from 3 London firefighters. In Scotland, the Scottish Government put it right 2 weeks ago. The Fire Brigades Union has a much better relationship in Scotland since the new government was elected, the conference was told. In England, the High Court upheld the decision and nothing so far has been done to put it right. However, General Secretary Matt Rack and some of his colleagues have been in discussion with government officials in the past 2 or 3 days in a desperate last-ditch attempt to salvage something out of the wreckage before this conference began. And it looks as though they may have achieved something, Matt Rack told the conference.
We're outside the High Court. We've just had the judgment in our judicial review regarding ill health pensions. We have been unsuccessful in that judicial review. The judgment has gone against us, and obviously we're extremely disappointed at that judgment. It potentially got huge implications across the fire and rescue service. We're discussing the full details of that with our lawyers, so I'm sure every Fire Brigades Union member will be disappointed at that outcome. However, on a more positive note, we are in discussions with the government about the guidance which has led to this position regarding ill health pensions, and we have made some significant progress there, and the government and other people within the service do seem to have an intention to try and resolve this as quickly as possible. Those discussions are continuing, and hopefully we'll be able to give some better news very soon. I'm well aware that emergency resolutions will be discussed, and I would expect that to be the case. The Executive Council will also need to discuss the possible emergency resolutions, and it will clearly be one of the key debates at the annual conference next week.
The position is that the 3 comrades from London have recently had the pension stop, got their pensions reinstated following judicial review. However, the further consequence of the judicial review we've just lost are yet to be established. Talks are ongoing at the moment. We're waiting to see what's going to happen with those talks. We're hopeful that there will be some sort of resolution to the whole process. The biggest problem we've got in London at the moment is the Board of Medical Referees, which is the resolution that we moved in was supported by conference. The problem we've got is that the Board of Medical Referees, the makeup of them, are so biased in one way towards the employers that the results speak for themselves. I'll try to get people removed from boards because of their obvious bias. The position is that the CLG and the employees are more than happy to leave those people in place. The problem we've got that, of course, is that our members are losing out because I don't believe they're getting a fair hearing. So our resolution basically spoke about having a different sort of appeal board, a tribunal, so it would come under legal standing, and that would make it, I believe, a fairer position.
This is about real people and real families and the hardship upon those families that has been created as a result of actions by civil servants at the CLG. And the issue that, of course, you'll all be familiar with by now, the issue that lies behind the problem that was created is guidance that was issued by the firefighter pensions team at CLG. And this followed changes to the firefighters pension scheme itself in 2004. And those changes were to redefine the definition of firefighter. And as we've explained at many meetings, that was to allow increased flexibility within the scheme, to allow redeployment where it was appropriate. And I think that gradually we've come to accept that there are many of our members who would seek redeployment in firefighters' jobs, who would rather stay on a firefighter's salary than be put out of a job. But they do expect to get a job out of it. And in terms of that guidance, what we ended up with, because the pensions team at CLG had various drafts of guidance, and eventually in their guidance to the independent qualified medical practitioners, they said this, that provided the member can carry out one of the duties of the role, he or she cannot be permanently unfit. They also said that the question of whether or not a job exists is not a matter for the pension process, So we end up in the bizarre position of people being assessed on the basis of whether they could do one element of their role map, even if no such job existed. It really is a catch-22, ridiculous situation to end up in. In our view, what that meant was that many firefighters would end up facing the prospect of no job and no pension. And that was not a position that we were willing to accept. It opened the door, in our opinion, for the ending completely of ill health pensions within the firefighters' pension scheme. It opened up the door also, in our opinion, for widespread capability sackings, because that would be the only mechanism that individual employers would then have to resolve that problem. Being unable to give a pension, having no job to give to the individual, they would have ended up sacking our members under capability. And that became clearer and clearer, to the extent that at the Firefighters Pensions Committee, we ended up with one stakeholder saying, well, we've got growing realisation that we will have to start sacking people under capability when they have done nothing wrong at all, except to be injured at work or to be suffering from some ill health that prevents them from carrying on at work, and therefore we should look at some sort of other cheaper compensation. We will explore now with Thompson's and with our legal advisors the issue of an appeal, because I think that judgment does need to be challenged and does need to be appealed. Suddenly, and in a bizarre turn of events, following the CLG's success at the judicial review, in the final meeting of the Ill Health Review Group, almost at the 11th hour before this conference was due to meet, we gave them a bit of an ultimatum. And we said very clearly, so that they could understand it, and we used simple words to get the message across. We said, we've got our conference in 2 weeks' time. You haven't delivered, and our conference is going to do whatever our conference does, and you better be prepared for the consequences. And I have to say, there was a very sudden change of mood in that discussion. There was a very sudden increase in urgency. They asked for some urgent meetings with us. And we've had a series of discussions with CLG officials since that discussion. And I want to be absolutely clear so the message goes back again. The discussions that have led to the production of the documents that you've now seen were with the Fire Brigades Union. Nobody else. The Fire Brigades Union. Because when it comes down to business getting serious, the government realise that there is one body to talk to, and that is us. That's yourselves. They're the only people who matter.